The Second Amendment to the U.S. Constitution is only 27 words long. Its meaning has been debated for more than 200 years. It states, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." Can you tell us what you believe the Second Amendment means?
You can carry a gun.
The right to bear arms, to own and have guns in our possession.
The right to bear arms for a well-maintained militia, I think.
It's unclear exactly what the framers meant here. I'm not sure that anyone has a definitive answer. If I received this from a student in a paper, I'd certainly strike it out and ask them, what the heck do you mean by this?
The best way to try and understand the Second Amendment is to tell you how the nation's highest court, the Supreme Court, has ruled in cases involving guns. But first, a little historical background and a close look at the words of the amendment. The first few words read, "a well-regulated militia." What is that?
The term militia is a state-based military force composed of civilians who are mobilized in time of national emergency, either for the defense of the state or the national government. And that's what the founders thought of. The Minutemen would be a good example of the militia. But does everyone view the term militia the same?
You go back to the framers of the Constitution, the militia was able-bodied male property owners who were white, okay? And then there's this idea that came out of that we're talking about members of the National Guard. So today, when we talk about the militia, are we talking about members of the National Guard? Or are we talking about all able-bodied white men who had property? I mean, it's really an open question. And the court really hasn't come down and said, this is what it is.
Here's where the Second Amendment gets a little murkier. The right of the people to keep and bear arms. What do most constitutional scholars believe?
The majority of the Supreme Court has held that it is meant to protect an individual's right, apart from the militia, to possess arms, to keep arms, at least in the home for the purpose of self-defense.
The right to gun ownership people love the second part of it, where it talks about the right of the people to keep and bear arms. It shall not be infringed. That to them means that you can't take away my right to own guns. And not only guns, but ammunition. And not only that, but any type of gun that I choose to own. So they take it literally.
Finally, the last four words of the amendment. Shall not be infringed. Does infringed mean?
You cannot prohibit people from firearms for certain purposes, and only certain types of firearms for certain purposes. Others would argue that the term infringe means that the state's ability to maintain a militia may not be impeded, may not be impinged upon.
It wasn't really until the last decade or so that the United States Supreme Court began handing down some important defining decisions on the Second Amendment. Two blockbusters here. In 2010, the court ruled on a case called McDonald versus the City of Chicago, and in 2008, a ruling called the District of Columbia versus Heller.
And there at issue was a District of Columbia law that essentially prohibited the possession of handguns in the home, even for self-defense.
The Heller decision held that the Second Amendment protects an individual's right to possess a firearm for lawful purposes.
I'm very happy that now I'm able to defend myself and my household in my own home.
However, Heller did not address the question of whether the Second Amendment extends beyond federal enclaves to the states. McDonald versus Chicago did.
And Chicago essentially had the same type of gun regulation that the District of Columbia did. The city essentially prohibited the possession of handguns.
McDonald determined that the right of an individual to keep and bear arms applies to the states.
There have been state gun control regulations since the founding of our nation. Regulation of firearms is not something new. It's something that has existed since, we became, a nation.
That's pretty much where we stand today. Future court decisions may change that.
It really comes down to a simple question. Is there absolute rights in the Constitution? When the Constitution says you have, for example, freedom of speech, is that an absolute right? Can I say anything I want to? And the answer is no, there's limits on that. And so the Second Amendment is really about limits. Is in fact this right to keep and bear arms totally free, totally absolute, or in fact is there limits on it? I think that both sides agree that there should be some reasonable limits. No one wants 5-year-olds running around with guns.
But the Second Amendment gives people the right to possess things that can actually kill. No other amendment is like that.